Hi, and thank you for watching this video on the CliniSync Restricted Health Information Exchange policy. The purpose of this video is to give you an overview or a primer on the restricted information policy, and then to schedule a follow-up meeting with your hospital to talk through any questions. First, I want to go over some supplemental documents that will be sent to you prior to viewing this video. The first document is the actual policy, so the CliniSync Restricted Information Policy. It's Policy L from the CliniSync Policy Manual. The second is the CliniSync Client Restricted Health Information Assessment and Attestation Form. This is a form that you'll fill out during your implementation to make sure that you've addressed all of the items that are included in this presentation and all of the types of information that are covered in the Restricted Information Policy. The third is a document that's used for educational purposes for both your hospital and physicians who have questions about this Restricted Health Information educational document. If you don't have these documents, please contact me and I'll make sure that you get them as soon as possible. The things we'll cover today are recent legal developments pertaining to restricted information and the key policy points in the CliniSync Policy L governing restricted health information. So first, to go over some recent legal changes. The first item I wanted to go over was a high-tech provision that was recently adopted as part of the HIPAA Omnibus. This became effective on will become effective on March 26, 2013. And the part of this law that is relevant to today's discussion is that patients have the right to request non-disclosure to their health plan for services that they pay for in cash or out of pocket. That information can still be shared with their treating providers, but it can't be shared with their health plan. And we'll cover that later in the presentation. The second is Ohio Revised Code Chapter 3798. This became law on September 10, 2012. This law aligned former Ohio state laws with HIPAA and simplifies the exchange of mental health HIV records for CliniSync participants. Federal laws do still apply, but this law aligned all of the previous Ohio state laws and case law with HIPAA. To go into a little bit more detail on the Ohio Revised Code Chapter 3798, I wanted to make sure that you understood that the purpose was to make the laws of the state of Ohio governing the use and disclosure of protected health information by covered entities such as yourself consistent with, but generally not more stringent than, the HIPAA privacy rule for the purpose of eliminating barriers to the adoption and the use of electronic health records and health information exchange. So Section 3798.04 goes over patient authorization to disclose PHI to HIEs. This new provision reiterates the federal HIPAA privacy rule requirements. So all uses and disclosures permitted by HIPAA without patient authorization, such as disclosures for treatment, payment, and healthcare operations, are permitted. The second item I wanted to point out, it pertains to immunity. This is in Section 3798.08. Under the new law, a provider is given immunity from civil and criminal penalties for accessing PHI from an approved HIE and for disclosing PHI to an approved HIE in a manner that complies with Chapter 3798. Now, I mentioned that an approved HIE, that's actually something that's yet to be, rules that have yet to be promulgated by ODJFS. The Ohio Department of Jobs and Family Services will be creating a process for HIEs to apply and receive approval from. That process has not been created yet, and when it does, we will, of course, comply with it, and we'll go under whatever steps are necessary to become an approved HIE. There's also additional rules that have yet to be created by ODJFS pertaining to written notice to a patient that their PHI will be disclosed to an HIE, and procedures for patients to request restrictions on the disclosure of PHI to HIEs. They also have intended to draft a standard authorization form permitting disclosure of PHI to an HIE. We believe that form will be very similar to the form that we use for consent for query. And again, we'll make sure that we keep you updated with all of the future rules as they're adopted, and we'll provide additional communications and information to you as needed. So now I wanted to go through some of the key policy points to the CliniSync policy on restricted health information. The first pertains to drug and alcohol records. The policy states that if you have a special unit or a program or staff that holds itself out as providing drug and alcohol diagnosis or treatment, you can auto-deliver related records only in a documented medical emergency. So in order to find out if you have a facility that provides this type of service, The easiest way to do that is to look on the SAMHSA website, and I have the address for the SAMHSA website listed under questions on the right side of this slide. So look up your facility and see if you receive funding from SAMHSA. If you do, then you likely qualify as a special unit that holds itself out as providing this type of treatment, and you need to comply with the terms in this policy. So if you are in that situation, you need to e-tag the records to prevent the query-based access through the community health record. And if you can't e-tag those records, you need to exclude the information from that special unit or program, because you can't redisclose the information that you received from a Part 2 provider or from a provider who receives funding from SAMHSA without an express written consent. So we haven't found that many hospitals have this type of unit, but again, the best and easiest way to find that out is to look on the SAMHSA website, use the treatment locator, and see if your facility is listed. If you have any questions, like with all the policies, please don't hesitate to contact me. The second is psychotherapy notes. Psychotherapy notes cannot be exchanged through CliniSync. I want to be very specific about what psychotherapy notes are. They're not considered part of the medical record. They're process notes that capture a therapist's impression of a patient, and they may contain details of conversations from a private or from a group setting. We don't want you to confuse psychotherapy notes with mental health records, such as progress notes. Okay, so again, psychotherapy notes are notes that are captured as part of a therapist's treatment of a patient in a psychotherapy session. So questions you should ask yourself is if anyone on your hospital staff provides psychotherapy. And if so, and they do, we need to make sure that your EHR or hospital system has the ability to exclude these records from our auto delivery services. You also would need to look at your hospital's policies and see if they are more restrictive in terms of sharing mental health records. And if they are, we can work with you to comply with that. We haven't had any hospitals to this date that are exchanging or sending psychotherapy notes. But again, if you have any questions, please don't hesitate to contact us. The next area is services paid in full by a patient. And this relates to the law that I previously mentioned as part of the recent HIPAA omnibus. So if a patient's paying you out of pocket for services and asks you not to disclose their information to their health plan, you can't disclose that information. You can share that information with other treating providers without any problem. The primary insurance associated with the encounter is what will be used to determine if the patient has restricted disclosure to their health plan. So I should mention that we are in the future planning to work with health plans to send information to them, and we'll work with the hospital to ensure that no information that is paid for out of pocket is sent to a health plan. I also want to take a step back and comment that we won't be automatically sending information to any health plan without the hospital's approval. And the hospital will also have to go through a separate assessment before we can start a project such as that. So questions you might want to ask yourself pertaining to services paid in full is if you have the ability to flag these services with the primary insurance of self-pay. And we can talk more about that in detail if you'd like to or if you have any questions. The next topic pertains to minors over the age of 14. So if you treat minors over the age of 14, they may have the right to consent to treatment without parental consent in certain cases, such as HIV testing, STD testing, and certain mental health treatment scenarios. If you want to disclose information about treatment consented to by a minor, you need to get the minor's consent to disclose. Now this doesn't come into play with the delivery of results. So in our phase 1, we're delivering results. If the physician has ordered the result, then they receive that information about that patient regardless of their age, because it's a one-to-one directed exchange. The situation with minors really comes into play when we turn on the ability to query exchange, which will happen in the next 6 to 8 months, depending on what region you're in. So when query-based exchange is available, any patient has to give consent. And when it comes to consent to minors, if a patient is of the age between 14 and 18, we'll need both the minor's consent and the parent's consent. But again, this isn't something that will come into play until we turn on the ability to query the HIE in your region. So questions you should just ask yourself: do you have a process in place to gather and record minors' consent in these instances? And again, all patients will have to give consent before their information is available to query on the HIE. General responsibilities. This section of the policy just covers the fact that you need to evaluate and apply the CliniSync policy within the context of your organization's environment and policies, and there may very well be instances where your organization's policy is more restrictive, and we have no issue with that whatsoever, and we welcome and will work with you to make sure that we capture and can technically back up whatever your organization's privacy policy is. Clinical information available through CliniSync may not be complete if the sending provider's privacy policies preclude you from sending it, but again, that's a decision that needs to be made at each organization's level. So questions you might want to ask yourself is if you've reviewed your exchange policy for VIPs, and if you need to work through any more restrictive policies you have for VIPs as part of your implementation. And then just discuss these issues as well as the previously mentioned ones with your legal counsel. I also want to mention that the restricted information policy covers both directed exchange and query. Your hospital is likely currently rolling out directed exchange, so direct delivery of lab results to physicians who have ordered them or physicians of record. When we move to query-based exchange, we'll provide additional information in the form of videos and educational documents to explain that process and to also explain any of the nuances related to that as it pertains to our restricted information policies as well as all of our other policies. If you have any questions, please don't hesitate to contact me. Again, I am the Privacy Officer for CliniSync. My email and phone number is listed on the screen. And again, please review the supplemental documents that hopefully were emailed to you along with the link to this video. And we'll be happy. I'll contact all hospitals to set up a follow-up to make sure that we walk through any questions and addressed any concerns. Thank you.